Just briefly, good morning, everyone. It's really great to be here with you today, and thanks Giuseppe for organizing this event. Once every year, at least, we touch base with IP matter. So, and it's great to have here again in Pisa Enrico, who's a frequent visitor of Sant'Anna and also dear friend with whom we have also a number of ongoing projects today. He's going to present a paper on one of his passions because he was always very much into pop culture and copyright. For those who don't know him, but I believe that this is not the case for the audience today, he's a reader at the City Law School, where he focuses on IP matters, and his research now for a couple of years now moved to copyright. Started from patents, but now copyright is his main expertise, and he's very well known for his social legal analysis of new forms of creativity or neglected forms of creativity like graffiti and underground creativity and comics. As part of them, it was always recognized as an intellectual property matter, but of course it is not being considered at the same level as visual art and music, for example. They're going to present today Enrico and Mahak Kansara, who's an attorney Bar Council of India, focusing on intellectual property matter. It's the co-author of in this paper, and they're going to present to us today. I don't think it has been published, right? It's just it's still a work in progress. It's a work in progress, and it's comics and copyright and intellectual perspective. We're going to listen to the presentation, and then we will open the floor for questions and comments, which I believe, since this is a work in progress, they're going to be very happy to receive. So without further ado, I pass the floor on to Enrico to resume from where he started before. Okay. Thank you very much.
Thanks, Caterina. Thanks, Giuseppe, for organizing this event. Actually, this is a paper that Mahak and myself are working on, and it will be, when it's ready, it will be a book chapter in a volume which is going to be edited by Giuseppe Martinico and Gianpaolo Rotolo, who is here with us today. It will be a book on comics and the law, right? So the book will address and will analyze legal aspects of comics in different areas. Our chapter, in particular, is going to focus on copyright aspects of comics. So, as I said before, it's a work in progress paper, and aim is to finalize it very soon. And in the next slide, as you can see, Mahak, in the next slide, we are going to see, sorry. I don't know, Mahak, if you can move. Okay, yes. We'll address here several issues. So first, at the beginning, a very short history of comics from the 19th century, especially in America, where it was born. But we can trace the birth of comics, or at least the concept of comics, from cave walls paintings, from cave walls drawings in the history. So here you have, as you can see, evolution of forms of copies from cave paintings until the latest comics produced by big multinationals such as Marvel and DC. In the next slide, we can see the first, what is considered at least the first ever comic book in UK in 1897. It was a simple collection of works previously published on a comic strip, marketed to kids, as you can see, the yellow kid, and it was marketed to kids due to its slapstick humor and short storyline. So could be considered as a prime precursor, as an embryonic example of comic. It was The Yellow Kid in McFadden's Flat, published in the UK in 1897. Then, afterwards, in America especially, we have the so-called golden age of comics. DC Comics' predecessor was a company called National Light Publications. We can say that they created the modern superhero. Huge sales of these comics such as Captain America, Wonder Woman, and Superman. It is interesting to note that we are in the 30s, so in the pre-World War II era. The comics in that era in America was serving a purpose, an anti-Nazi propaganda, basically, to raise the morale of troops and so on and so forth. So it was a clearly political propaganda purpose surrounding that period for the recruitment of young men into the army, into the United States Army. Very, very interesting curiosity. In the next slide, we can see that, as we go through the decades, the civil rights movement of the 60s in America, America's social progress led to superheroes of color, of course, black superheroes. Black Panther, for example, was one of them, and they take center stage in that period, late 60s, early 70s. It's the birth of the so-called Dark Ages, where the art styles and narratives would take darker, attitudes, darker tones. Superheroes become humans in a certain way. Narratives include the use of alcohol, drug addiction amongst. So it is a kind of humanization, let's say, of comics in that particular period. And lately, of course, as we progress to the 80s, of course, Japan takes center stage, right? Towards the early 80s, I would say, when Japan starts becoming a superpower in economic terms, in entertainment, comics. I come from an age when I was a kid in the 80s, and all comics, all cartoons were Japanese production at that time, right? So in the 80s, a new style took over the world, the Japanese comics, known as manga, no? It's an art form from the old black illustrations that have been present throughout Japanese history, right? And then, of course, the 90s, the 2000s, we have the rise and consolidation of multinational, right? DC, Marvel, Disney. Disney already also before. America here, of course, leads the way, no? Okay, so this was a short historical evolution to put everything in context. So in our paper, we will have a section, introductory section, a short one, contextualizing the history. Then the next step, the next slide, and here is where Mahak now will present on the copyrightable elements of in comics, no? What can be protected, both, as we'll see, both literary works, the written parts, and of course the figurative parts, the artistic works. So Mahak, over to you. I will get back later when talking about fan fiction, which is a very important aspect of comics. Mahak, over to you.
Yes, thank you so much, Enrico, and thank you so much everyone for having me here for this lecture. Am I audible properly?
Yes, perfect.
Perfect. Okay. So I'll be covering the topic copyrightable elements in comic book, and I'll be also talking about the reoccurring legal battle that comic book faces with regards to authorship. So let's get straight into it. So before we decide the copyrightable elements in a comic book, it's very important to know that we all know that copyright exists in the expression of a particular work and not the idea. So we are aware of the idea expression dichotomy. And so the idea is not protected, the expression of it is protected. And one might wonder why this is relevant in the context of copyright. So this is because a lot of comics are based on similar ideas. And so if idea were to given protection, then we would have monopolies in comic book stories as well. So let's understand this with an example of sort. So we all see the storyline, the idea behind the storyline of a comic sometimes get pretty basic and common. So a common storyline would be that a normal human comes into contact with a foreign or a dangerous substance and gets superpowers. And an extended version of it would be that once, as they get the superpower, they're unaware of how to exploit it, but later learn it and use it for public good. So this is a common idea. What matters is the expression of this idea. And this is actually the storyline of a lot of superhero comics like Spider-Man. Spider-Man gets beaten by a spider, or Hulk also. Hulk gets Hulk gets exposed to gamma rays and gets angry and turns green. So this is a common storyline. Another example of a common storyline would be the story coming of age of an orphan. So a lot of times the common storyline idea is that an orphan loses his or her parents in a very severe and tragic condition, and then later gets on to live with a relative, and the relative bullies the orphan, and then later it gets power. So that is the storyline. So this is important to understand that the idea, it's very common in a lot of comic books, but idea is not protected. The expression of that idea is protected. For this, we also have the case law of International News Services and Associated Press. These were two news agencies who were reporting on World War I in the US. And for some reason, International News Service got banned from reporting. And so what would they do was access the stories of Associated Press and make it as its own. So change the expression. So they gave way to the idea expression dichotomy. Now, now that we know what is not protectable, let's talk about what is protectable in a comic book. So a lot of examples that I'll be using today and we'll be using today would be based out of the US, because they have a big industry and popular cases, and everyone can relate to those cases. So the first thing about the copyrightable element would be the storyline. So a storyline is considered a literary work, just like any other novel. Next would be the protection of dialogues and narrations and settings and events. So here one more doctrine comes into the picture. When somebody describes a particular setting, it might come under the doctrine of savoir-faire, and savoir-faire talks about the common settings which are common to a particular time period or a situation. So for example, if an artist were to describe a medieval town, they would use certain references, certain words which would be unique to that, which would be appropriate for that medieval time. And so nobody who uses those words to describe, or those sentences to describe that setting, can said to be using original words, and therefore not protectable. So here another protectable element in a comic book is the artistic work. Since a comic is a combination of words and images, the words form the part of a storyline and are protected as literary works, while the artistic work protects the images and the illustrations and the drawings in a comic. And it can go to the extent of even a costume, for example. For that, we have the Varsity International, the cheerleading uniform case. And so those are the artistic elements. Even the cover of a comic book is protectable that way as an artistic work. And at this point, it's very notable to understand there are a lot of things which are not protected under copyright law per se. Those are short phrases or titles. And so big corporations like Marvel or DC, they protect these short phrases and titles through the use of trademark law. And so these are the copyrightable elements in the storyline. Now we'll move to the copyrightable element in terms of the comic book characters. So comic book characters can be protected as well if they have a certain unique physical and emotional trait which is very unique to them. And so one might think that all kinds of characters would be protected even in a fictional book or a novel, but that's not the case, because comic book characters are defined in a certain way, have physical elements which are very natural to them and very monopolistic to them. That is why there is protection. But fictional characters, on the other hand, do not have this. If they have this quality, then they are in fact protectable. But most of the times they do not. So to understand what character is protectable, there is a test of sufficiently or well delineated test. This test talks about what are the prerequisites that a character needs in order to be copyrightable. So comic book characters should have specific physical or personality attributes, like we talked about Hulk. So Hulk is green in color, and Hulk, when Hulk gets angry, Hulk becomes a giant and starts destroying things. So these are things which are very natural and organic to the description of Hulk. And these are the identifiable attributes to which we can identify that the comic book is talking about Hulk even in different contexts. And the last thing would be the unique elements of expression that must be represented consistable. So this is what the test says. And now that we've understood what are the copyrightable elements, I would like to take some time to talk about two very interesting cases. So first is the Walt Disney Productions versus Air Pirates. Under this, it's very important how important are the emotional or physical traits. We see this in this case. So in this, Air Pirates copyright infringed the Disney characters, and they showed various Disney characters, including Mickey and Minnie, engaging in a vulgar setting or using substance abusing. So this was held that these characters, Disney has protection over how these characters are depicted in the public setting. So I guess even the moral right concept would also come into play here. And now the most important case would be the national elite corporations versus faucet publications, which in simple we call the Superman versus the Captain Marvel. So this case is very important, as this is the longest comic book case ever to go on, and this talks about the comparison between two superheroes. So DC owns Superman and Fawcett owned Captain Marvel. And Fawcett had a habit of actually trying to infringe on DC's copyright. So what they would do they earlier came up with something called Masterman. And when DC filed suit, Fawcett sold all the rights to Masterman and shut it down. But later, Fawcett came up with Captain Marvel. And Captain Marvel took over, and it became so popular that it also got movie rights. And so the main issue came was when Republic Public Pictures, they wanted to make a movie on Superman, but because Superman's TV rights were already with Paramount Pictures, they could not do so. So they instead went with Captain Marvel. And so DC filed a case and said that Captain Marvel is a direct copy of Superman. And the Fawcett replied to this allegation is that the Superman's characteristics are mere of a person having superpower, which are already too common in comic settings. For example, we see Tarzan having various superpowers which no normal human would have, or even Popeye for that example. So they claim that this was merely a setting and nothing which would be specific to just Superman. To this DC, they came up with a list of all the common things between the two. So as you can see in the picture here, common elements are they compared the capes of the two superheroes, the boots, the costumes, the ability to fly, the ability to leap great distances or be invincible to bullets and shield. And in the picture below, you can also see that they have a similar face cut. So they made a list of all these common comparisons, and the court held that this is definitely a direct and a shameless copy of Superman. And so Captain Marvel at that time was shut down. And once it was shut down, Marvel, as we know today, the Marvel Corporation, it bought trademark rights to the term Marvel. And a few years down the line, Fawcett sold a lot of its superheroes to DC itself. And so DC got the right to Captain Marvel as well. But they could not revive Captain Marvel because the trademark Marvel was with Marvel Corporations. And so instead, DC renamed it to what we know today as Shazam. So this is the copyrightable elements that we see in comic books. Now that we know that comic books have book corporations have copyright, what can they do with these copyrights? So the first and most important thing is they can enjoy protection against infringement for the life of the author plus 70 years. I've taken 70 years here because we will be talking about US the most, and so Berne Convention has life plus 50 years, but US has life plus 70 years. They have the right to reproduce the work, and they have a right to create derivatives like TV series, motion pictures, and what video games, and today we know metaverse as well. There's one more important thing here, and a funny thing here is that one superhero or one comic book character can have very different, slight changes to its personality in TV and movie at the same time, because these rights are very different and are sold individually, assigned individually. So, the most common way you and I naturally understand the copyrights of these comic book companies is through merchandising. So we can see a kid with a Avenger tiffin wearing a Batman t-shirt. So these are merchandising that you and I know. And then hero companies, the comic book companies, they also indulge in immersive experiences like theme parks. So these are what can be done with the copyright. Now we come to the constant legal battle over authorship. So authorship in general sense, as we know it, rests with the creator or the author who first creates the work, and that person is generally the first author of the copyright. But in terms of media companies, this is not how it works. So there are a few employees and a few freelancers that work with these companies. And so when any work is done during the course of employment, this is a natural work for hire, as it's a natural work for hire, and the rights are transferred from the employee to the big corporation companies. So they get the right. But for freelancers, if there is no agreement, then the rights rest with the freelancer or the artist itself. And in terms of agreement, when they sign an agreement, they generally give up a lot of rights. For work made for hire agreement for freelancers, they give up a lot of rights. So when DC and Marvel, companies like DC and Marvel, when they work with freelancers, they make them sign the work made for hire agreement, and with which they transfer all rights to these companies. And so on a particular superhero, there could be an interesting team working that could be full of employees of the companies plus also freelancers. One great team is of Stan Lee and Jack Kirby. We see them working together over the years in a lot of superhero developments. The most popular is the Fantastic Four. So once we define whether a person is working as a freelancer or as an employee of these comic book companies, it is important to now also understand the termination provision. So termination provision is a very important provision in the US, where the author of a particular work has the right to recapture the copyrights associated with the work that he had previously assigned or transferred. So this can be applicable after 56 years of the assignment, and you have to give a copyright notice to the assignee that you want to recapture the rights back. And this is what Jack Kirby's family did. So Jack Kirby was involved with Marvel in making the Hulk, the X-Men series, and the Fantastic Four. So their heirs, they sent recapture notices to Marvel. And Marvel said that this is a work made for hire, and so Kirby was, even though was a freelancer, there was a work made for hire, and he had transferred, so not of and any right to have recapture. The court declared that it was in fact the work made by Kirby was in fact made under something called the Marvel method. So the Marvel method was very popular with Stan Lee. So what Stan Lee would do as an employee and editor-in-chief of Marvel was that he would sit with a few freelancers and just have a conversation with them or speak to them about their superhero or what storyline they would like to see next in a very loose context. And then the freelancer would come up with comic strips. These comic strips would be then finalized by Stan Lee, and Stan Lee would have the final say in whether or not this goes into into publication or it comes into existence in front of the audience or not. So this was the Marvel method, and drawings that this is actually a work made for hire, and they came up with the test of instance and expense. This this test talks about instance or whose order or instruction was the work generated and who had the final say, and how was the freelancer paid. So these are the defined whether.
Mahak, sorry.
Yes.
You keep freezing, I mean, the image. Perhaps you can try to switch off the video, because
Yes.
we might get the audio better. Thank you.
Yes. Okay, so with this we come to the why there's a reoccurring pattern within the corporation and individual authors. It is because of the termination rights and the right to recapture, and even termination endangers. And heir to the creators of Doctor Strange, and have all submitted termination notices to Marvel. And if they win, then Marvel would have to share ownership and also share profits with the heirs of these authors. The constant issue of doesn't Marvel will lose protection over all these superheroes, because like I said, behind a superhero there's always a team working. So some people working in the team would be employees of the of Marvel, and some would be freelancers. So the rights of the employees already belong with big corporations, and so there will naturally be something called joint authorship. Now, what's the issue with this recapture, and why did it come into picture in the first place? This is because big corporations generally, while they are going for the for taking control of a superhero or bargaining the rights to a superhero, they generally have the upper hand. And small individual authors, they do not have these rights because firstly, do not understand the value of the work. They do not understand how to exploit it, so they give away their rights at very cheaper expense, I would say. And a lot of time also, what Marvel or DC does is that it buys a lot of rights to a lot of superheroes, but they do not bank it. So they only bank a select few. And some superheroes are probably just, sitting in some document somewhere in Marvel and DC. And so the authors, original authors, can have the right to exploit it again if, they can recapture it. Also, why is recapturing a problematic thing in comic book industry is because it gives a certain sense of uncertainty in the ownership. So because if a particular superhero can be recaptured a few years down the line, then for company it's a very big risk to invest in the constant transformation and development of these fictional characters. So a company does that. Media corporations put in a lot of time and efforts and money to make a character, to keep a character relevant. They come up with plot twists and events, and they try to keep the emotional connect between the loyal customers, the loyal viewers, and the superheroes. So they invest a lot. And so if recapturing is a very common phenomena, then if recapturing is common, then of course they are always under this uncertainty of whether they own the superhero or not, or whether they should invest in the superhero or not. So this is also against the principle, the objective of copyright law, which works at creating a certain certainty in the ownership of copyright. I mean, who owns the copyright? That is one of the objectives of the copyright law. So this is kind of turning against the whole objective. And the work, when the work is evolved, at the same time there is sometimes a provision of sort where the original authors are not very happy with what the big corporations are doing with the character. For example, let's take Sherlock Holmes. Sherlock Holmes, personality is someone very, aloof and, distant and, lacking empathy and, a cold person, I guess, somebody who would not understand emotions. So this is the general characteristic of Sherlock Holmes. But in the recent time, we have seen, Sherlock Holmes being, having certain element of feelings or having a family. And so these are the changes which the author might not approve of. And if they have the recapturing rights, then they of course can capture the superhero back and make it the way it is. It always was in their mind. But the recapturing right, so recapturing right in the US is very important, because in other countries like the India or India or France, there is the concept of moral rights, which Enrico will deal with later, and which authors who are not satisfied with the way someone treats their copyrighted work, they can always claim the moral right in it, and just turn it into something of a protect the institution, the base institution of that character. So this is Enrico will deal with this, and so now I request Enrico to
Yes.
take over the discourse.
Yes, we are going now to focus on first fan fiction, which is quite a significant part of the paper. I guess everybody in this room is aware of this phenomenon. Fan fiction is where fans of the comics, they create their own version of the comics, the storylines and stuff. It has always been there, even in the pre-internet era, right? Of course, with the advent and development of the internet, I mean, the internet has made writing and reading fan fiction more accessible and popular. So it has increased significantly. In Japan, for example, there is this phenomenon, the doujinshi. Doujinshi is understood to be to mean manga or anime featuring characters not originally created by the author, and fans typically in Japan sell their doujinshi at special conventions. That's a commercial activity, not huge commercial gains, but it's a commercial activity. While most fan fiction is not for profit, right? Fan fiction people, they create their own version just for fun, for commenting purposes. But this, particularly in Japan, is for commercial purposes. Very little fan fiction is as commercial as doujinshi. Then we have the phenomenon of fan subbing, anime fan subbing in particular, which has been studied by some scholars, particularly in Bristol. Anime fan subbing is the practice where very committed fans of anime copy the anime and translate from Japanese into another language where there is no product in the for example in America, right? They subtitle it and they release the subtitle version on the internet to share it with other fans, for example in America, which cannot read Japanese. So there is a very important social function here to make it accessible in another language in a market such as the United States, which is an important country where anime manga is so popular, right? Of course, they do that without asking permission from the copyright holder. So it's a phenomenon, it's a practice especially developed in Japan for the US market. And it is a practice which, however, is good for the copyright owner because especially the digital fan subbing over the internet, and it corresponded with the growth of the anime industry in the US. So it has worked as a sort of springboard for the consolidation of the anime industry in the US. We could call it a win-win situation, right? That's why copyright owners often do not take action. They tolerate because they see that there is a win-win situation. Apart from that, of course, fan fiction in theory would be an infringement of the reproduction right, the distribution right, and the adaptation right. But as we can see from this slide, very often copyright owners tolerate fan fiction. And they tolerate because, especially fan fiction, which is not commercial, right? Especially in Japan, but not only. Rebecca Taschenet, in a paper of 2017, highlighted how copyright owners have generally realized that, threatening their fans with the legal action does not make really sense, right? You don't sue your own customers, right? I mean, in other fields of creativity, I remember in the music field, Metallica sued many of their fans for peer-to-peer file sharing, peer-to-peer file sharing. I would say that it's not really a commercially wise move to sue and to take legal action against your own fans, right? But this was another story. So, as I said, it's often a win-win situation, right? Also, US anime publishers sometimes browse fan subs for market research purposes. This was highlighted by Lee in her paper. And have conversation with fan subbers. So you can see here how there is a collaboration between fan subbers and copyright owners. So there are, as I said, the examples of direct collaboration between fan subbers and the industry. For example, a specific example, a fan subbing group provided Tokyo Pop, one of the large anime publishers in the US, with a translation of a specific initial deal. It's a typical example of good collaboration. So, what about fair use? We come back to the previous slides when we talk about fair use. Can fan fiction people, fan subbers, rely on fair use in America to escape any finding of copyright infringement? Well, at the beginning, in the 90s, in the pre-internet era, fan fiction, when they published the paper magazines, they used to put a disclaimer, right? We are not authorized, we are not official, we are just fans. And now it seems that disclaimers are less common, as highlighted by Rebecca Tushnes in her paper. Most fan fiction, we could say, however, at least in America, that most fan fiction might be justified under fair use, right? Under US copyright law, because they are transformative. Most of them are transformative, right? One of the important factor is transformativeness of the copyrighted work. It might be arguable that the more transformative the fan fiction is, less will be the threat and harm to the original, right? Well, what about one of the two factors? You know, for the fair use analysis, there are factors to be taken into account. The first factor is, you know, the nature of the use. I mean, most fan fiction people, apart from in Japan, they do it not for profit. They do it for pleasure, commentary, praising, you know, what they love, and so on and so forth. So in this case, of course, there is a strong presumption of fair use, right? When there is a non-commercial cultural use of a copyrighted work, of a comics. What about the fourth factor, or that is to say, the impact on the market of the original comics, right? Well, again, here, the issue here is whether the infringing work, the fan fiction work, usurps the market of the original by being a substitute. Well, again, this is not the case for most fan fiction, because in fact, fan fiction does quite the opposite. It increases the appeal, it increases the exposure, and it encourages new readers to read and buy the original work. So as far as the first and the fourth factor are concerned, it seems that most fan fiction works would be eligible for fair use, right? Also, again, with reference to fan subbers, most fan subbers believe that fan subbing has been a solution to correct the market. Through what? Through temporarily offering translated work and subtitled works, anime, and therefore fulfill consumers' demand until a legitimate product is presented. So if there is no translation in a particular country, fan subbers do this, do satisfy a demand in a country where there is no translation. You can see again here the effect of fan subbing is to promote anime culture in general and encourage demand. Again, this phenomenon was studied by Lee who is an academic in Bristol. So it can be seen that in the US, fair use might be available. Funny enough, there is no case. There is no case on fan, well, we have not found, we have researched it, but we have not found any case on fair use. Why? Because copyright owners don't take action. And they tolerate exactly because of these, on these grounds. It's a win-win situation often. It may increase the market rather than decreasing, and so on and so forth. What about Europe? In Europe, the situation is more difficult. We know that in Europe, we don't have a broad fair use doctrine as broad as in the US. So in Europe and in UK, we need to look at specific provisions in the Info Society Directive, in the UK Copyright Act, and so forth and so forth. So, for example, the exception for criticism, commentary purposes, that might, as I say, might because we don't have cases, so we are speculating. Yeah. So in the paper, we need to speculate on this part, on fan fiction, because we don't have cases. So, yes, criticism, comment exception, both under UK and the EU law, parody, if the fan fiction might be considered a parody. Not all fan fictions are parodies, because, you know, fan fictions is a very broad category of works. You may have fan fiction for parody purposes, fan fiction which is very similar to the original work without ridiculizing the pastiche as well. Pastiche exception has not been interpreted so often under EU law. So again, we don't have a clear picture. But in the literature, we have found some authors that have highlighted the fact that the pastiche exception might be available. A test for pastiche would likely cover the following features. So the use of the part of the comic which evokes an existing work is satisfied, of course, which must be different from the first work. This might be satisfied or might not be satisfied, because if the fan fiction is very similar, no, to the original, and it must be an intellectual and laudatory comment of the author on the previous work. So there must be this component, the laudatory comment, the laudatory element, such as to be a dialogue with the work, with the upstream work. And of course, the underlying work must have been made available to the public. That's what. If these conditions are met, the pastiche exception might be available. But as I said in the paper, we are speculating on it because we cannot rely on cases in America, in the EU, and in other countries. Then there is the issue of moral rights, right? In the next slide, moral rights here might be relevant, especially when the copyright owner does not approve of the fan fiction. You know, there might be fan fiction works that are disparaging the underlying work. They might be unwelcome interpretation. They might perceive, at least by the copyright owners, as unwelcome interpretations of the original works. And therefore, here the moral right of integrity might be relevant. You know, the right to prevent treatment of the works which are considered to be prejudicial to the reputation or honor of the author. And I would say that the integrity right might be at stake here. The attribution right, so the right to be recognized as the author of the work, this is less relevant for particular couple of reasons. First reason is fan fiction people usually acknowledge the authorship of the origin of the author on a disclaimer. But even if there is no disclaimer, an average consumer might understand the fact that this is fan fiction, and therefore they don't want to usurp fan fiction people. They don't want to appropriate any authorship, let's say. And so this is a part of the paper that we are going to highlight, also with some fantasy examples, because we don't have cases. Then what about creations by fan fiction people? Can fan fiction works be protected by copyright? Right, that would be a derivative, right? If they are original, of course, why not? They need to comply with the originality requirement, and we know that the originality requirement differs from country to country. We have the US test, the modicum level of creativity. We have the EU test, intellectual creation, UK test, skill, labor, and judgment. And of course, in theory, they could be protected. But what we have found in our research is that most fan fiction people don't want to protect it. It's a part of the so-called IP negative space, right? They don't really care about protecting their own creations, exactly because in most of the cases they do it for non-commercial purposes and just because they are passionate about it. Also, fan subbers have developed their own rules and social rules and social norms, which show their love and passion for what they do. There are some exceptions, of course. For example, fan subbers seem to show some respect of copyright principles. For example, they show respect for corporate owners' exclusive rights, right? By acknowledging. And also fan subbers, they stop do fan subbing when the market is served by the corporate owner, right? So we need to summarize a bit because I see that Giuseppe is sending me some, so just the 2 minutes. Mark, maybe I can continue myself on the public domain issue, because here,
Yes, please go ahead.
yes, comics, like any other copyrightable works, corporate hands after a while, or should I? But I remember, that in 1998, the US passed the Mickey Mouse Act, the Sonny Bono Act, which was called Mickey Mouse Act exactly because it extended the copyright for other additional 20 years exactly to address concerts made by Walt Disney. You know that in America, lobbies are so strong that they can buy laws. This is Lawrence Lessing uses these terms. They lobby congressmen and congresswomen and in that case, the copyright was extended exactly because the first Walt Disney comics were about to enter the public domain. Well, of course, in the paper we are mentioning this because the comic world has been one of the engine for such. The comic industry has been one of the engine for such extension. So in the paper, we really hope that there will be no further extension lobbied of the corporate term lobbied by the industry, by the comic industry, by the entertainment industry, exactly because we don't support this, and we don't agree with the US Supreme Court decision in Eldred, which has confirmed in 2002 that extension of copyright, especially for Disney works, was constitutional. So in the paper, we are really objecting to that. Sorry, Mahak, I think we need to finish because we need to open the discussion, right? Sorry about exceeding the time. Thanks so much, Mahak, again for and now we are waiting for questions and comments.
We stop the recording.